Hey everybody, it's Rob from foundingthefuture.us, and this is your 5 Minutes of Freedom. I wanted to take just a second to say thank you to everybody who checked out my last video, #StandWithOrlando, whether that was on Facebook or YouTube or at foundingthefuture.us. I really appreciate all the comments I got on Twitter and on Facebook and everywhere, even those who contacted me directly. It touched a nerve, as gun control and guns usually do. But that's a good thing, because if we're talking, at least we're working on a resolution. If you haven't had a chance, check out that previous 5 Minutes of Freedom video, #StandWithOrlando, and check out one of my extra videos, which is an excerpt from the Oh the Anthem podcast where we discuss that same exact issue. Now, I wanted to take an opportunity to dive a little deeper into the Second Amendment and the guns issue. And of course, the place to start is at the beginning, with the Second Amendment. Now, I'll say off the top that a lot of people make a grammatical argument when it comes to the Second Amendment. You're not going to hear that from me. I'm not an English major. I was a political science major. So I'm not looking at grammar, I'm looking at political and historical context and looking for a meaning in today's world. There are in fact several versions of the Second Amendment that were sent out to the many states because several different printing presses printed up the Constitution after it was ratified at the convention. Different versions of the Constitution have commas in different places, which could possibly change the way that someone who's more familiar with grammar would read the phrase. But you're not going to hear me use the terms ablative absolute or prefatory clause, two ways that people determine whether or not certain parts of the wording apply to other parts of the wording. I think this argument gets away from what is really meant by the amendment. So here's the heart of the issue. Let's give it some context. Free people have all of their rights, absolutely. The Constitution is meant to be a limitation on government, not on the people. The Bill of Rights was an answer by one group to another group about concerns that individual liberty may be jeopardized by a federal government. Keep in mind, the colonies were just coming out of a situation with a strong centralized government, and a lot of people didn't want that. The purpose of the Bill of Rights was to enumerate a certain number of rights that pointed out that the government may not infringe on these individual liberties. It's been well settled in case law before the Supreme Court, and in fact in statutory construction, in the 18th, 19th, 20th, and even the 21st century, that these rights are individualized. So you're also not going to hear me jump into a conversation about whether or not they apply to people individually. That is settled. So let's look at the amendment itself. All grammar considerations aside, the Second Amendment says this: a well-regulated militia, being necessary for the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, at minimum, that statement is broken up into two clauses. The latter, being the most important to most people, is that the right of the people to keep and bear arms shall not be infringed. The former, being the ablative absolute or the prefatory clause, is less important to some and alternatively more important to others. But again, we're looking for a political and historical context. So let's break down the important words in this amendment. First, and perhaps the one that everyone points to, is the reference to the term militia. Now, in modern times, we think of the militia as the National Guard, and perhaps that's correct. Maybe in modern times that is a militia. But I think it's important that we don't confuse the modern interpretation and what the intention of the founders were. After all, it is the policy of the Supreme Court and of the Congress to look back in intention and say this is what they intended and we must move that intention into the future, not take our current understanding and modify what was said in the past. Now, my academic writings are all in the realm of history. Therefore, I love going back to primary and secondary source materials that were created at the time or around the time. They give us a better idea of what people were intending when they were writing those words. I think a really important thing to go back to is to look at the founders and find out what did that word militia really mean to them at that time. Well, how about this? Let's go back to 1776. George Washington, who participated in the Constitutional Convention but arguably wasn't a big player, defined militia in a letter to one of his generals as this. He said, "I am unacquainted with the extent of your works, and consequently of the number of men necessary to man them. If your present number should be insufficient for that purpose, I would then by all means advise your making up of the deficiency of the best regulated militia that could be got. Some might likewise be useful in bringing up supplies, and fill the place of men who would render more service with arms in their hands." Here we see that exact term, a regulated militia. But it doesn't make any clearer the issue of what is a militia. Well, how about this? George Mason, who is sometimes called the father of the Bill of Rights, he's a man who argued that the enumerated rights listed in a Bill of Rights would be very important for individualized liberty, was quoted as describing the militia as this. A worthy member has asked, "Who are the militia, if they be not the people of this country, and if we are not to be protected from the fate of the Germans and Prussians, and by our representation? I ask, who are the militia? They consist now of the whole people, except of a few public officers." Now keep in mind, when we think about fighting a war today, we think about a well-organized army, a professional army, a volunteer army. But that did not exist in the colonies in 1776. When you are imagining Lexington and Concord, when you're imagining the first battles around Massachusetts, in Maryland, and even all the way down into Georgia, what I want you to picture is this. A call goes out across the town that men are needed, men at arms, and every man, whether he was a cobbler or whether he was a blacksmith or whether he was a farmer, would grab his small arms, his musket, and rush out to the field. This call for men at arms actually goes way back in English history, even back into the 14th century. It goes back to the concept of a hue and cry, which I'm not going to get into now, but basically what it meant is that all the townspeople, all the able-bodied men should stand up and come out and answer the call. When colonists, when Americans were killed at Lexington and Concord, those were just able-bodied men, regular citizens who grabbed their small arms and went out to meet the greatest fighting force in the world at that time, the British Army. But that's just my conjecture. Let's look for a little bit more of historical documentation. In the Militia Act of 1792, Section 1, where militia is defined, it's defined as this: that each and every free, able-bodied white male citizen of the respective states, resident therein, who is or shall be of age of 18 years and under the age of 45 years, except as hereinafter accepted, shall severally and respectively be enrolled in the militia, by the captain or commanding officer of the company within whose bounds such citizen shall reside, and that within 12 months after passing this act. So here we see further that the idea of the militia was every able-bodied man. And putting aside the ages and the race of these people, obviously you have to give that in a historical context as well. Because keep in mind, the original Constitution classified black citizens, whether they were free or slave, as 3/5 of a person. So we see that their intention was that the militia be every able-bodied man. Now, the Militia Act, the one that is dictating how the militia is organized, or how it's well regulated, said that men must sign up with their local precinct captain. Now, this is not available to us now. And it's certainly not the same as the National Guard, because keep in mind, the National Guard acts far more like a branch of the military than it does a militia. And in fact, some states have a separate militia that is different from the National Guard. Now I want to jump forward a bit, because I think the current U.S. Code actually gives us a little bit of mentality of what is a militia intended to be. Is it the National Guard? Is it just every free able-bodied man? Well, I think the answer is right there in the U.S. Code. Title 10A, Chapter 13, subsection 311, describes the militia as this: the militia of the United States consists of all able-bodied males, at least 17 years of age, and except as provided in Section 313 of Title 32, under 45 years of age, who are, or who have made a declaration of intention to become, citizens of the United States, and of female citizens of the United States who are members of the National Guard. Now, the second section of that separates the organized militia from the rest of the militia. It says, the classes of a militia are the organized militia, which consists of the National Guard and the Naval Militia, and the unorganized militia, which consists of the members of the militia who are not members of the National Guard or of the Naval Militia. Now we can jump in here to what do all of these terms mean, but I think it's especially important to look at subsection B2, where it describes the unorganized militia as all other members of the militia who are not members of the National Guard. Now who could they be describing? Well, those are everyone in section A above. Males, 17 to 45, unless specifically excluded, and females who are members of the National Guard. Now what we can see from this is that from 1792 to the current U.S. Code, that what is a militia is clear. It is all able-bodied men. Now, of course, when I say able-bodied men, I'm using a historical context for men. It would certainly be more politically correct for me to say able-bodied persons, able-bodied citizens, because I could tell you that I know women out there that shoot far better than I do, and they are members of the militia as well. Anyone who is a citizen or has made a declaration to be a citizen is a member of the militia. So let's look at another word. How about well-regulated? Well, specifically regulated, because well is a modifier for that word. Now, a lot of people put the definition, the modern definition, of regulation into regulate, meaning that laws have been passed which adjudicate what a militia is. But again, we need to keep a historical context. What did regulated mean to the founders in 1781 to 1791 when they were building the Constitution? Well, Johnson's Diction of the English Language, which was published in 1755, defined regulated as this. It is the past tense of to adjust by rule or method, or to direct. Now we're getting into the weeds here. Let's look in that same dictionary and find out, what does adjust mean? Well, that same 1755 dictionary defines adjust as to regulate, to put in order, or to make accurate, or to make comfortable. Let's go even farther into the weeds. What does direct mean? Section 2 of that first definition. Well, it defines direct as to aim in a straight line, to point against a mark, to regulate, to adjust. So now we're getting into a little bit of circular logic here. Definitions referring back to other terms. But let's look at another source. The Oxford English Dictionary defines regulated as governed by rule, properly controlled or directed, adjusted to some standard, of troops, properly disciplined. So when we're looking at the term well-regulated in a historical and political context, we are looking at something that is not meaning regulation like law, but properly directed, a well-directed, a well-controlled militia. So going back to Washington's letter, what did he mean by best regulated militia? Well, I think if we look at it in historical context, we can say that Washington was directing his general to go out into the public, grab all the able-bodied men that he could, but only the able-bodied men that were likely to be directable, to be put to action, and get them together so that he can supplement his regular army, the Continental Army, with those irregular troops. Now, I don't want to dive into the definition of irregular troops. Certainly, the 18th century and the 21st century have much different definition of regular troops, insignias, and what those things mean. But in this time period, regulated troops simply were anyone who were act on behalf of a general, whether they were in insignias or of the local populace. So, a well-regulated militia being necessary to the security of a free state. Now, again, I'm not going to analyze the word state here. As people probably know, state has many different applications. The United States, we are individualized states that come together as a country. On the international scale, a state is a country. And I think that the Constitution, a document that was directing the formation of a country, and thereby uniting the states, state here was used to mean the entire country. So therefore, again, a well-regulated militia being necessary to the security of a free state. A directable group of able-bodied citizens being necessary to the security of a free state. We've defined all of those terms. We've given them a historical context. And none of that has to do with any sort of regulation of an army. It is simply the ability of a civilian crew to take direction if necessary, and how key that is to the security of a free country. Again, keep in mind, this was a group of people who had just earned their freedom from a despot, from a monarchy that had sought to keep them down. So they were looking to address the issues of an arising central government, and they were looking to avoid falling into that trap of control once again. So let's look at part 2 of that phrase. The right to keep and bear arms shall not be infringed. Again, let's keep a historical context. The Constitution is a limitation on government, not on the people. Therefore, by this clause, we see that the people have a right to keep and bear arms. Do we want to get into a historical definition of what keep and bear is? If we really get into the weeds on those particular words, then I think we are missing the complete point. Let's use a natural definition of keep, which has lasted from then until now. To keep is to have. A natural definition of bear is to use. So the right of the people to keep and to use arms shall not be infringed. Now I do want to take a moment to address one of those words there, the word arms. Because one of the arguments I continue to hear from people is that, well, the founders had no idea of the armament that we would be able to have today. They were only envisioning a single-shot musket, which allowed you to get off 3 rounds if you were an expert per minute. They were never envisioning the 15 rounds per minute, the 15 rounds per second, some people say, that modern weapons can put out. But that's not exactly true. Our founders were men of the Enlightenment. They knew a lot about the modern conveniences, and they knew a lot about what was going on in the world. They were well versed in the technology of Europe, and in fact, John Adams, Thomas Jefferson, and many of the founding fathers spent a significant amount of time in Europe during the Revolutionary War. Now, while in Europe, they would have found that there were armaments that allowed for multiple shots. There was a 7-round revolver. There was a 9-round revolver. There was a rudimentary machine gun in Europe at that time. Can you imagine being on a battlefield in the 18th century and seeing a flintlock machine gun being operated? Boggles the mind. But it was out there, and you have to imagine that these men who were in Europe to buy arms to support a revolution would have gone out seeking out those very things. I think it's ignorant of us to assume that they would have not known that in the same time period and before, multiple shot armament had been developed. They knew that it was out there. More importantly, they fought a war, essentially at the beginning, using almost solely militia. Eventually, a continental army was organized, but at the beginning, it was simply able-bodied men, farmers and blacksmiths and cobblers, who came out because they loved this country, what country there was, and they wanted to fight for it against an oppressive regime. What did those farmers have? Were they put at a disadvantage? No. They had single-shot muskets, the same as the British. Now, perhaps the British were more proficient, although it's been argued that an American frontiersman probably was better with his rifle, especially at distances, than any average redcoat. So as I pointed out in my last video, I think the point of this is to keep parity. Even having the argument that they could only envision muskets. Well, the British were only utilizing muskets in their small arms. So what they envisioned was the ability of free men in the militia to have parity with the armed forces. Now, I want to address another issue that has almost continually arisen during this discussion. It's somewhat related to the previous point, and that's that the founders had no idea looking forward what kind of technology we would have today. And my argument against it is this. It goes beyond the fact that they knew that other technology was on the battlefield. It goes more to the fact that the remainder of the Bill of Rights has been applied to modern life pretty easily. No one would argue that the First Amendment doesn't apply to the internet, as far as press is concerned. No one would argue that the freedom of religion is only for those religions that existed in the 18th century. Looking at other amendments, no one would have been able to envision cars or computers or cell phones back in the 18th century. In fact, that's probably more far-fetched than the idea of a multiple firing armament. But no one would question that the phrase persons, houses, papers, and effects applies to a computer, it applies to a cell phone, and it applies to a vehicle. So why is it so easy for us to move those other amendments into the modern time, but we hold back so much when it comes to the Second Amendment? As I've said before many times, my argument is simply this. I believe that all the amendments are equal. I think that they are meant to be limitations on government, not on the rights of free men, and that free men who abide by the social contract should get all the benefits of that social contract, including the right to peaceably assemble, the right to practice religion freely, the right to free speech, the right to keep and bear arms, the right to be free from unreasonable searches and seizures, the right to not testify against oneself, the right to a reasonable bail. All of those rights held in the first 8 of the amendments should apply liberally to everyone. But it's the Second Amendment alone that is subject to such scrutiny. And I think that does a disservice to all of us as citizens, and it, in a way, reduces what it means to be free in this country. No one has to sit and do this kind of analysis when it comes to any of the other amendments, and I think that that's problematic. Now, I don't want to take the time to be too repetitive, but I do want to say that this does not mean that I think that guns should be completely unregulated. Similarly, I don't think that the First Amendment, the Fourth Amendment, the Fifth, the 6th, 7th, 8th, that these amendments should go completely unregulated either. It has been the policy of the Supreme Court that a reasonable restriction, so long as it doesn't interfere with the underlying right, is perfectly fine, and I agree with that. A religion has to establish some kind of legitimacy to get the protection of the amendment. Free speech doesn't cover you when you shout fire in a crowded theater, or if you are actively trying to start a riot. Your right to be free from searches and seizures is subject to a warrant, which can be issued by a court. It's not absolute. The key in all of these things is the reasonableness, and that's what we need to address. As I've said, I don't believe that regulated in the Second Amendment really applies to laws. That doesn't mean that we shouldn't pass smart gun control reform. If you as a responsible gun owner are afraid of testing, then I'm afraid of you. If you're afraid to show proficiency with a weapon before you can purchase it, before you can keep and bear it, then I'm afraid of you. As part of the social contract, we need to be protected from each other. That's one of the roles of government. And part of the reasonable restrictions is just that, protecting us from each other and not allowing freedom to run rampant so that others get injured. If you're a responsible gun owner and you're afraid of mental health testing, I'm afraid of you. If you're a responsible gun owner and you're afraid of background checks, I'm afraid of you. If you're a responsible gun owner and you think that being on some kind of restriction list, whether it's a terrorist watch list or a no-fly list, shouldn't garner you some extra scrutiny, I'm afraid of you. In my mind, these are all reasonable restrictions which allow us to maintain a freedom that is guaranteed by the Constitution, but be able to assure that everyone is safe from those exercising that right. Just the same like shouting fire in a crowded theater. So let's not be so absolutist about this. Let's put a little logic in this argument. Let's do the right thing to maintain freedom, but also to protect people. As someone who fully supports the protections and the guarantees of the Second Amendment, I'm not afraid of that. While I will say that I do believe that gun ownership is a right and not a privilege, the way that driving is, I think that we can look at driving as an example to how this can be done. If I can show proficiency with a weapon, I should have access to that weapon, no matter what the weapon is. There's been a lot of talk about quote-unquote assault weapons and how they are different than regular guns. But what I will say is this: if I can show proficiency with that weapon, why shouldn't I have access to it? Because again, the Constitution is a limitation on the government, not on me. The reasonable restriction is me showing that I am proficient with it, that I am safe with it, that no one else will be endangered by my ownership and my possession of it. So test me for my handgun. If I pass the proficiency exam, if I pass the mental health examination, if I pass every test that you can throw at me, and I will, then I should be able to have that handgun. More importantly, I should be able to have that concealed carry permit. Why? Because the government is restricted by the Second Amendment, not my personal rights. My right to possess a weapon is absolute, subject to reasonable restrictions. If I can show proficiency with that shotgun, and I can pass all the other mental health evaluations, I should have access to that shotgun. The same with long guns and assault rifles and any other small armaments. Let's start treating them all the same. They are, in fact, dangerous weapons. Every time one is discharged, you run the risk of taking a life. Let's not look at a .223 assault weapon as something that's more dangerous than a .223 hunting rifle. Let's not one be subject to a 5-day background check and the other be sold over the counter at Walmart. And most importantly, let's be respectful of the debate. I've spent a lot of time over the past few weeks listening to the perspectives of other people. I hope that you've taken a chance to listen to my perspective here, even if it was a little more than 5 minutes. This is Rob for FoundingTheFuture.us, and this has been your 5 minutes of freedom. Stay safe out there, and have a great week, everybody.